So one of the chief innovations of the Model Penal Code from 1962, it's one of the things the code is most known for and most celebrated for, was the distillation of the huge array of mental states that we know exist in the world into 4 workable, clear definitions. And I don't think anyone thinks that those 4 definitions actually exhaust the ways in which people behave, but in the absence of a standard that would allow us to cover the millions of different subtleties in the ways in which people think, and also in the absence of what had been in the common law, even disagreement using the same words as to what those words meant, the Model Penal Code's ability to really try to capture these 4 tiers of mens rea has proven truly landmark. And for that reason, they've been widely adopted. They've been adopted by states. The Supreme Court has cited them. And I will say empirical work, research has shown that when you give the definitions to lay people, they can apply them accurately, that they actually do understand them and apply them consistently across fact patterns. So what are they? Essentially, there's 4. The first is purpose, and purpose is usually associated with the idea of a conscious object. This means that it's not just something you know will happen, or you are doing, or is there, but something more. It's something you want to be there, something you intend to be there. It's your conscious object to bring about. And you can see how that really matters, because someone might want something that's actually really uncommon or unlikely. The second mens rea, or the sort of stepping down, is knowledge or knowing. And knowing is what I just suggested. It's the obvious kind of intuitive meaning, which is you know something to be the case. And that's associated with the idea of practical certainty. And I think this is important because colloquially, again, people say no when they don't really mean no, when they mean hope, like purpose, or even when they mean something less, like I know he's cheating on me, or I know he's, not going to be there when I show up, or I know she's going to be late. When you don't really mean that with practical certainty, it means you think there's a risk, or a trivial or substantial risk, or you hope, you mean something else. But in the Model Penal Code, no is awareness with practical certainty. The next step down is what's known as recklessness. And generally, we think of knowledge and purpose as specific intents. Recklessness and negligence are more in the general intents. I know with practical certainty, but awareness of something less. And what that less is a substantial and unjustifiable risk that represents a deviation, a gross deviation from the standard of care of an ordinary law-abiding person. So what does this mean? It's more than just an awareness of any risk. And that's for 2 reasons. One is because the code itself says substantial risk. So if you're just aware of a trivial risk or a possible risk or any old risk, you're not reckless, because you need to be aware of a substantial risk. And more importantly, it needs to be not just substantial, but also unjustifiable. So I might be reckless if I think there is a substantial risk I'm going 30 miles over the speed limit, but it may not be unjustifiable if I'm rushing to get a sick person to the hospital in time. So unjustifiable helps us understand recklessness even in the presence of substantial risk, and substantial risk helps us understand in turn justifiability. And all of it gets wrapped up as well as to grossly deviate from the standard of care of a law-abiding person. Is kind of the overarching notion of recklessness. Then lastly is the mens rea of negligence. And negligence is a sharp break from our 3 other mental states of recklessness, knowledge, and purpose, in that negligence requires no conscious awareness on the part of the person as to the risk. So it's similar to recklessness in that it requires a substantial risk, it requires that it be unjustifiable, and it requires a gross deviation. But here the difference is the proof standard doesn't demand subjective awareness on the part of the actor as to those things. So you don't have to be aware of that risk or of its substantiality or unjustifiability to be found negligent. And those are essentially the 4 mental states. So the Model Penal Code sets what's commonly called a floor or a default of recklessness in the absence of a specified statutory mens rea. Why is that the case? I think there's a couple answers to that. One is a theoretical answer, which is the Model Penal Code drafters in 1962 felt very strongly that the distinction between culpable actors and non-culpable actors, or between people who might be liable for money damages or liable in tort, and people who should be liable for punishment, the criminal sanction, was about mens rea, that was really one of the turning points that separated private wrongs from public wrongs, that separated, kind of wrongdoing that did not deserve criminal punishment versus wrongdoing worthy of punishment. It was the culpable mens rea of the actor. And so the Model Penal Code, in its own commentary, said it was sort of launching a broadside attack on anything short of culpable awareness as a baseline threshold for penal liability. So in 2.02 of the 1962 Code, it essentially says that in the absence of a specified mens rea in the statute, you must presume that this recklessness standard is the floor. It also says that you should presume against strict liability in all instances unless it has been clearly and ambiguously spelled out, which means the absence of mens rea should not be read ever to impose strict liability and should be presumptively not read to allow for negligence. And then it also has some other features where if a legislature, say, adopted one mens rea, purpose, knowledge for a particular element of a statutory offense, 2.02 also tells the judge or interpreting legal official to apply that mens rea to every other element in the offense. And I think if you were aware of a substantial risk and it's unjustifiable that it was without permission, you should be liable, you can impose recklessness as to that element, but that doesn't authorize negligence or strict liability. You would not be able to say either, oh, well, they put knowingly over here in the statute and there's nothing here, so it's strict liability. Model Penal Code would reject that outright. Or even say they put knowingly here and I don't think that that was their purpose for this element, so I think negligence is appropriate. Model Penal Code would also reject that and say in the absence of a specified mens rea, where the existing mens rea seems to not have not apply, recklessness should be the presumptive floor. And again, that's sort of in keeping with the general orientation of the code, which is that subjective culpability on the part of the actor is a critical sort of condition for the imposition of a punishment in criminal law. So this one's a little trickier to answer because I'll be completely candid. Those of us in the inside world of criminal law who teach and work with the Model Penal Code on a daily basis, we've internalized these rules, as sort of, second to air in terms of their obviousness and their application. And that's obviously not the case, not just for non-criminal law scholars, but even judges or others who work in the field who just don't work as much with directly this portion of the code. So this has presented us with several dilemmas. The first is that one reason for these interpretive rules is simply efficiency, expedience, and economy. If I had to put a mens rea in front of every single clause, it would be just really cumbersome. It might be very clear, but it would make for a very long and annoying code. Knowingly take an item you know to be more than $500, when you know you don't have permission and it just becomes really cumbersome. So the code's rules allowed for you to eliminate a reference to mens rea or to economize your references to mens rea, aware that the background principles would apply. So if you look at the 1962 code, there aren't mens rea clauses throughout it, and it works with recklessness because the absence of a specified mens rea means recklessness. Similarly, you'll see a statute that will have, or 1962 code provision that will have knowing or purpose, and again, because of the background rules, that means every element will have that particular mens rea. So the economy of it, the kind of efficiency of it is great if you are a scholar of the Model Penal Code. But early on in the project, we realized not everyone was a scholar of the Model Penal Code or wanted to be, and that in particular for a code intended to go into the world, not just into case books, but into the world and have real meaning, it would be helpful to be clearer about these background principles and also to be clearer even in the statute themselves for legislatures who might pick and choose. Because some of our advisors and the members of the council raised the concern that if you were to just take part of our code and put it into your code without realizing this background principle, you might not realize as a legislature that you even were neglecting questions of mens rea or that they had been answered by the code elsewhere. So because of that, we do something that is unorthodox for the rest of the 1962 code, which has caused some of our scholars to be less than thrilled, but which is to repeat the mens rea throughout and to put that in explicitly as recklessness. Now, we don't do it in the kind of most absurd way, which is to say we don't put it after literally every element because that would just be too annoying for everyone. But we do put it in each statutory provision such that it's very clear, this is the mens rea for this provision. And anyone who looked even a minute into it would see that it applies then to every other element without much controversy. And so that's been kind of our way of using the 2.02 rules to our advantage, while also ensuring that the broader community of legal actors and legislators who might see this revised code understand its meaning and its impact. So I think there's two dimensions to the debate or the dispute that we've seen around the use of recklessness. One is a substantive dispute and one's a dispute about form. So let me just take each in turn. The substantive dispute, I think, arose most pointedly earlier, although I think there are still people who have this objection to the code. And that is just whether that's the right mens rea. Some people might say, I think knowing should be the right mens rea here. Others actually have advocated that negligence should be the right mens rea. Sometimes we apply a knowing mens rea to a particular term, and people say, I think that's unjustified. Recklessness is in fact the norm or should be applied. And so the substantive debate about mens rea is which mens rea is appropriate for each element of offenses, and how should we think about that? I think we've resolved a lot of those questions, although certainly not all of them. And so that will be a source of disagreement. And I think in understanding how these mens rea work, it's really just essential to understand the lines between not just knowledge as awareness with a practical certainty and recklessness, which is awareness of a substantial risk, but also understanding proof standards in court and the difficulty of proving mens rea more generally, that it's often the case as you need to prove something beyond a reasonable doubt, and the thing you're proving is what's in someone's head, that the very demanding standard of knowledge is a really meaningful bar. And so understanding the dynamics of proof, the dynamics of plea bargaining were things that went into our consideration and what was the appropriate standard beyond just what do we think is sort of abstractly correct. The second thing that's sort of a form and sort of a substance dispute, I think, is in the civil law, in tort law, recklessness doesn't require proof of subjective awareness of the risk. Another way of saying that is that in civil or tort law, the legal standard allows someone to be kind of imputed to be reckless if the risk was high enough or the behavior was unjustifiable enough. And that's therefore a really important distinction to draw. Whatever the case, it is unambiguous in criminal law that recklessness requires subjective awareness of a risk. That is true in the Model Penal Code's black letter, and it's true in the way that the courts across the country in criminal law and criminal cases apply the recklessness standard. You cannot prevail in a criminal case on a recklessness standard in the absence of proof of subjective awareness on the part of the actor of the substantial and unjustifiable risk. So that's a kind of form, kind of substance. It's substance in the sense that I think some people more steeped in the civil traditions or in private law fear that recklessness could come to mean this private law meaning, that it's not what they intend. But it's also kind of a form problem, because in the end, I don't think they do dispute that it is what it is in criminal law. The last aspect of the dispute, which has been the most difficult, is let's assume we all agree, which I think many people do, that recklessness is the right standard for a particular provision. How do we express that in the actual black letter doctrine code? How do we put that into the statute itself? Some sort of purists, I might call them, of the Model Penal Code say you don't write anything, because that's the Model Penal Code's 2.02 rule. Don't put a mens rea if the default is recklessness. As I explained, others say you can't not write anything. If you don't write anything, jurisdictions will get their hands on it. They won't know about 2.02 and they'll apply strict liability or negligence, and that's at odds with our intention. So then other people say, okay, fine, we can compromise. Let's just put the word recklessly in. But then critics come back and they say, I don't like that word recklessly because I worry about the civil definition that doesn't require subjective awareness. I'm worried that when people see the word reckless, they think of reckless the way you say reckless to your friends, which doesn't usually mean a substantial risk. So we have had drafts that we said reckless and disregarding the risk. And then people say, well, we don't know if it's a substantial risk. Okay, so then we said reckless and disregarding a substantial risk. And then people said, well, what about the unjustifiability? You're dropping that out. And then we said, reckless in disregarding a substantial unjustifiable risk. And then people said, well, this isn't good because now we don't have the gross deviation. So then we changed reckless to knows, or we changed reckless to awareness. I literally have a list of all the formulations in the drafts over the past decade in which we have tweaked here and there in response to these concerns. And I don't mean to minimize or diminish the concerns. It's a very legitimate question, but I do think that we have experimented now with almost every possible variation on the theme, and we've finally kind of alighted on what we feel most comfortable with. It's definitely not perfect. We're getting yelled at by the purists. We're getting yelled at by people who worry about civil law. We're getting yelled at by people who prefer a partial definition, even if it excludes other parts. But I do think that the reason we like our formulation, or have settled on our formulation, is that we feel it gives enough of a clue that this definition directly ties to the 2.0 due definition, that you can't have a partial understanding of it, that it gets rid of some of that civil law or silence concern, while not giving a partial definition that then just raises the question, why is it partial? Do they deliberately mean to exclude the other portions? What's the relationship between this kind of weird new language and the established 2.02 standard? And so we were very mindful of having a definition that captured 2.02 without partially replicating it in a way that would just raise questions about its relationship to 2.02. And so I don't know what will happen in the annual meeting. These are very inside baseball problems that may or may not have a ready solution in a meeting of this size and scope. But I will say the most beneficial thing about the process for me has been to really get outside of the academic MPC and think about the working MPC out in the world, and make sure that what is most important, which is that the meaning of the standard doesn't get lost as a result of a drafting choice, is realized, that we're protecting the substance at all costs, and the form is really just a vehicle for ensuring the substance is accurately transmitted.